He stumbled into the police station before sunrise, barefoot and trembling, his hands split open and leaking bright blood across the tile. The night air still clung to him. He stared at his palms like they belonged to someone else, flexing and wincing as if waking from a hard anesthesia. "I think I killed someone," he said, voice flat and distant. The desk officer stood up, taking in the gashes, the pallor, the shock in the young man's eyes. "Who did you kill?" the officer asked. The answer came out as if dragged from deep water. "My in-laws." Only hours earlier, in the early dark of May 24, 1987, 23-year-old Kenneth James Parks had fallen asleep beside his wife in their Scarborough, Ontario apartment. His life had been buckling under pressure for months: gambling debts, a fraud charge, a job lost in disgrace, and the crushing shame that came with it. Yet his wife's parents, Barbara Ann and Dennis Woods of Pickering, still treated him with steady kindness. He had promised himself he would tell them everything and ask for help. He had told friends the same plan. Stress shredded his sleep. He thrashed, talked, and gasped awake. Family members had seen it for years, the old habit of rising and moving without waking fully. That night, he closed his eyes. His mind did not settle. Sometime around 4 a.m, Parks rose from bed. His wife did not stir. He dressed with mechanical efficiency, picked up his car keys, and walked out the door. A neighbor heard nothing. He drove east toward Pickering, a familiar route of about 23 kilometers on quiet roads he had traveled many times while awake. The car already held a tire iron. At the Woods' home, the door was not locked. Parks entered. Inside, the house held the ordinary silence of sleeping rooms. Barbara Ann and Dennis rested in separate bedrooms. The details that followed became the center of a courtroom and a country. Barbara Ann was attacked with a knife and fatally stabbed. She also suffered blunt force blows. Dennis was strangled and struck, left bloodied and barely conscious, but alive. The struggle left a kitchen knife bent and surfaces marked by violent contact. There was no note, no disguise, no attempt to clean up. When the assault ended, Parks returned to his car, drove to a nearby police station, walked inside barefoot and bleeding, and surrendered himself with the sentence that started the case. Paramedics rushed him to a hospital. The cuts in his palms were deep, through skin and into tendon, consistent with gripping a knife during a twisting, chaotic fight. Surgeons would repair the damage. Police secured the scene at the Woods house and documented what they found. There were clear injuries. There was no evidence of alcohol or drugs. When detectives interviewed Parks, he answered calmly, but with a blank confusion that did not shift across hours. He remembered going to bed. He remembered standing in the station. The middle was a void. Investigators began pulling at the threads. They learned he had been stealing from his employer to cover gambling debts and had been charged with fraud. He had been fired. He faced court dates and family disappointment. On paper, there was pressure that prosecutors could call motive: money, fear, shame. But there was also his immediate surrender, the lack of any attempt to flee, and a life without prior violence. Relatives described a long history of sleep disturbances, walking, talking, even eating while asleep, stretching back to childhood. Co-workers said he nodded off at odd hours in recent weeks. His wife described nights of thrashing and muttered speech that he never remembered in the morning. Doctors examined him. A battery of tests followed: neurological evaluations, psychiatric interviews, sleep studies in a monitored lab. Electroencephalogram readings showed patterns that specialists associated with non-REM parasomnias, episodes in which a person could perform complex movements while the brain remained disconnected from conscious awareness. The results did not prove what happened that morning, but they painted a medical picture that made it possible. The term that entered the record was automatism, behavior performed without voluntary control. The Crown charged Parks with first-degree murder of Barbara Ann and attempted murder of Dennis. The defense announced they would argue non-insane automatism due to sleepwalking. In the courtroom, medical experts explained sleep architecture in plain language, how the brain cycles through stages, how arousals can occur from deep sleep, how a person may appear awake, eyes open, feet moving, while awareness is missing. They emphasized the triggers that had stacked up in Parks's life: extreme stress, irregular schedules, and sleep deprivation. The prosecution pressed a different logic. Parks drove a car for nearly half an hour, entered a house, selected or seized a weapon, attacked two people in separate rooms, and left. Those acts, they argued, required intention and control. The jury listened to days of testimony. The defense called witnesses who had seen Parks sleepwalk in the past. They described how he could talk, move through rooms, and even navigate stairs while clearly not awake. The prosecution cross-examined the sleep specialists at length, challenging the idea that anyone could drive while asleep. The defense responded with case literature documenting complex learned behaviors performed under automatism, especially in familiar environments. They returned to the early facts. Parks had turned himself in immediately, repeating his confusion. Toxicology was clean. There had been no attempt to hide or destroy evidence. In the middle stretch of the trial, one question held the room. Was driving possible in a sleepwalking state? It sounded to many like a bridge too far. Yet specialists testified that well-learned motor sequences can emerge in parasomnia, especially when the path is deeply familiar. They pointed to the documented injuries in Parks's hands as consistent with an unplanned, violent struggle rather than a calculated attack. They reminded jurors that automatism is not absence of movement. It is absence of conscious control. When the jury returned, the verdict stunned much of the country. They acquitted Kenneth Parks of murder and attempted murder. They accepted that he had been sleepwalking. The judge released him. Outside, reporters crowded the steps. Parks spoke briefly, voice tight, expressing sorrow for the Woods family and gratitude for those who had stood by him, including relatives of the victims who chose not to turn on him. Appeals followed. In 1992, the Supreme Court of Canada upheld the acquittal, concluding that the actions were the result of non-insane automatism. The court drew a clear line in Canadian criminal law. Guilt requires a voluntary act guided by a conscious mind. If a person's body moves without that direction, the law cannot punish as if choice were present. The decision entered law schools, police academies, and medical classrooms, a case study at the edges of responsibility and biology. None of it restored what had been lost. Barbara Ann Woods had been a mother, wife, and grandmother, remembered for her plain kindness and steady presence. Dennis carried scars, pain, and memories that woke him in the dark. Their daughter lived at a fault line, grieving her mother, caring for her father, and standing beside a husband a jury had said was not criminally responsible. Holidays arrived with an empty chair and a new careful quiet around the table. The verdict decided the law. It could not decide the heart. Clinicians used the case to talk about prevention. They taught families to treat sleep disorders early, to secure doors, to address breathing problems at night, to reduce stressors that can fracture the border between sleeping and waking. Sleep laboratories trace the outlines of parasomnia with better tools and clearer language. The point was not to excuse harm, but to keep it from happening again. Years later, officers still remembered that first minute in the station. A barefoot young man, gray with shock, leaving drops of blood behind him as he said, "I think I killed someone." It did not sound like a script or a defense. It sounded like a person recognizing a disaster that had already occurred. The route between Scarborough and Pickering remained the same on a map. For the people bound to that morning, it stretched a lifetime. The questions the case raised never fully settled. people asked how far science should bend common sense. If a person could drive while asleep, what else could the body do without the mind? The law's answer stayed precise. Criminal responsibility requires a voluntary act. The human answer stayed complicated. Grief does not measure brain states. By the time headlines faded, the Woods house had new locks and a different quiet. Parks built a life under medical guidance, keeping regular hours, avoiding the stress spirals that had once swallowed his sleep. He did not chase attention. When he did speak, it was to say he wished that night had never happened, that he would carry what he could not repair. The facts remained fixed. A young man under crushing strain went to sleep. He rose, moved through the worst minutes of his life, and turned himself in with torn hands and a voice that shook. A jury and a Supreme Court concluded that in the only way the law recognizes for guilt, he had not been there. The family carried what the law could not. Thank you for listening to The Lantern's Tale. Subscribe for more true stories, if you dare.